Welcome to our webinar on New Jersey's new mediation program. My name is David Gutowski and I'm a lawyer with Reed Smith. I'm joined today in the office with Matt Setzer, one of my colleagues from Reed Smith's State Tax Group. Reed Smith is a global law firm with 1,600 lawyers, and our state tax practice is one of the largest in the country with 35 lawyers in offices throughout the country. But today, we're talking about one of our focus states, New Jersey, and we're pleased to have Alan Kline, the Counsel to the Director of the Division of Taxation here, joining us remotely. Thank you for participating, Alan.
Thank you, David. Good to see you.
Good to see you. Now, Alan got his JD from Seton Hall and then his LLM from NYU. After that, he clerked with the U.S. Tax Court and then joined the IRS, where he litigated dozens of cases. And then, I guess just about 10 years ago, joined the Division of Taxation, where he wears a number of different hats, from controversy to regulations to legislations. And now he's with us to talk about the division's new mediation program. So Matt, do you want to start us off and give us a little bit of background about the program?
Sure. So most of the items that we're going to discuss today are included in the division's technical bulletin 115. There are going to be some things that aren't touched on as much in that technical bulletin, so Alan is with us to flesh those items out. As far as some initial background and warm-up questions, Alan, we'll get started. As you can see from the technical bulletin, the mediation pilot program is a 24-month program, starts this fall, October 1st. At the start of the program, it's only going to apply to corporation business tax and sales and use tax. We'll talk about later on how the program may eventually be expanded to other taxes after the close of the pilot program. It's also our understanding that both assessments and refunds can qualify. So this isn't just a program that applies to audit assessments, but it will apply to refund claims as well. Get started with some background questions, Alan. What was the Division of Taxation's impetus for starting this type of program?
Well, again, thank you for having me today. Well, taxation believes that mediation will save taxpayers and taxation time, money, and effort. And as anyone who has brought a case to the tax court or filed a protest with appeals can tell you, it can take anywhere from a year to several years before a tax controversy is resolved or finalized. And during that time, taxpayers are paying accountants, attorneys, perhaps case experts, and they're accruing, penalties and interest. And in addition, the controversy takes its toll, too, on the people involved, and especially the taxpayers, due to the uncertainty that's involved, the lack of control they may feel they have over the situation. They have to hope that a tax court judge or an appeals officer will see the case as they see it, and that's not always the case. But with mediation, you have an opportunity to resolve the controversy relatively quickly, with less cost, and the taxpayer can take back some level of control over the process and be involved in resolving the matter.
So we have the second bullet on this slide about, is one of the goals, the acceleration of revenue collection. But I think you did a nice job of summing up that this has a positive effect for both sides. It's to speed up the process and to help both taxpayers and the Division of Taxation close out cases. It's not necessarily tied to revenue collection. Would you say that's a fair summation?
I think that's fair. There are many goals as part of this program. And certainly, yes, taxation's perspective is to expedite the collection of assessed taxes. There's certainly a time value to money, and the sooner you can collect an assessment or partial assessment, the better it is for the division and for the state. But there's much more. A resolution by mediation means that the appeals officer who would have otherwise been tied up with this matter is free to work other cases or other projects. Similarly, the Deputy Attorney General in Law and Public Safety, who would have otherwise been involved in preparing and arguing a tax court case, or at the appellate level, they'll be freed up to work other matters. So it helps in conserving government resources, but there's more to it than that. And the idea of accelerating resolution is the primary objective here.
Now, will this, do you think, have any impact on the audit function? Will audits proceed the same way? Mediation happens at the end of the audit. Will there be any shortening or efficiencies as part of the audit with the thought that, well, we'll just figure it out in mediation?
No, not at all. And the thing is, the audit process will remain the same. It's just that the end of the audit process will now differ. As we point out in the technical bulletin, there will now always be a post-audit conference with the taxpayer where cases are unagreed. Always. That's not the case right now. It will be. And at that audit conference, the taxpayer will be clearly apprised of their ability to go and have mediation, that it's available to them. They don't have to take it, obviously, but it's an option that will be made available to them. And at the post-audit conference, they will be provided a mediation agreement, which they would enter into with the Division of Taxation, a mediation application, and if it's required, an extension, a consent agreement to extend the statute of limitations if it's required, because we need to have sufficient time to try the mediation process.
Now we've long heard about the division's backlog of cases at both audit and the second administrative level, the conference and appeals branch. Is that still something that is a thing, that there is a backlog of cases? And if so, could you put a number on the current inventory at the Division of Taxation of audits and refunds that are at both the audit branch and conference and appeals branch?
Well, I'll have to defer on that to Mike Bryan, but what I can say, though, is that there has been considerable development in alleviating the backlog, that's been done over the past year. And but of course, there's still some backlog at both CAB and at the audit level. And certainly, again, one of the many goals of mediation would be to help fully eliminate those backlogs. So that's certainly, again, one of the objectives of the program.
And we've certainly, in our practice, have seen things speed up over time and the division take efforts to resolve the backlog of cases. So this will just be another thing in the division's arsenal to speed up some cases and bring resolution to cases. Last question about background of the mediation program. Are there a portion of audits that the division has kind of already selected that they think will enter the program? Is there going to be case limitations or capacity limitations on the mediation program, or is it just going to be open to any case?
Yeah, how many cases can a single mediator handle in a year, you think?
Well, that is what we are going to find out. At this point, we believe if there's a reasonable number of requests for mediation, we will be able to handle that backlog. As of right now, there's 6 mediators that have been assigned duties beginning on October 1st. So they each have the capacity to work multiple cases, and that's what they will do. However, we don't know at this point the number of taxpayers that will come forward seeking mediation. We just, at this point in time, we don't know. We're hopeful that we'll have a good number, but it's still something that we don't know with any certainty at this point.
Okay. Moving on to some additional background on the process and procedure of mediation. As Dave had mentioned early on, and Alan, you too, mediation will begin at the end of the audit. Taxpayers will be notified of the mediation process And it only applies, that mediation process only applies to amounts in controversy in excess of $5,000. That's why we asked you on the last slide about that $5,000 threshold. It's important to note that mediation is not
just to be must exceed. No, it can equal or exceed. Just to be technical.
Okay, that's a good point. We'll keep that in mind, and that's a good point for our audience as well. Couple other points before we get into the questions. Mediation is not going to be binding on either party. So if a taxpayer is not happy with the results of mediation, they could end the mediation process, as I'm assuming the Division of Taxation can as well. And then you'll go through the normal course of procedure up to Conference and Appeals Branch and tax court if necessary. As far as the confidentiality of the proceedings, I know we'll get into this some more, but all mediation proceedings are going to be confidential, such that what happens in the mediation stays in the mediation. You cannot use what happens in the mediation at some later point in time, whether that be at Conference and Appeals Branch or whether that is at tax court. And I know, Alan, you want to make a point about that as well.
Yeah, I mean, I imagine some taxpayers are going to be a little skittish about that point. I mean, can you elaborate a little bit how you can maintain that sort of confidentiality to ensure, that there's candor between the parties?
Well, we are bound, the Division of Taxation, as any government entity would be with respect to mediation, by the New Jersey Uniform Mediation Act, which strictly requires confidentiality with respect to the mediation proceedings. And we intend to strictly follow that. So anything that is said or done or exchanged during mediation will be confidential. Now, that doesn't mean that independently down the road, there could be independent means of producing certain evidence or certain documents, but it won't come from the mediation proceeding, I can tell you that. We are going to strictly follow the Uniform Mediation Act, as we are required to do.
Then just a couple questions, Alan, about the mediation process. Does the Division of Taxation already have a selection criteria for the types of cases that it will select for mediation if a taxpayer submits an application?
I can tell you that, again, the basics are it has to be a sales and use tax case, not a gross income tax case, or a CBT case. It has to be $5,000 or more in controversy, not taking into account penalties and interest. And there's certain parameters with respect to what has happened during the audit. If the taxpayer was not cooperative during the audit, refused to produce documents, just wouldn't cooperate or respond, we feel there's no point in having a mediation with that sort of taxpayer. If they weren't cooperative during the audit, they'll be uncooperative during the mediation process too. So it would be a waste of time.
At the end of the day, it teaches everyone just to play nice in the sandbox, right?
Well, exactly. Because
no issues are off the table. This could include any substantive issue, constitutional issues, anything?
Any issue that relates to the audit. As far as raising anything in the whole scope of things, no, we have to limit it to simply what was part of the audit.
What about offset issues or refund issues? Is there any scope there?
No, if they're tangent, things that are related, then, we can include those sort of things, but they have to be really involved with the issues that are being audited.
And then can the Division of Taxation also apply for mediation? I know that much of the technical bulletin deals with taxpayers and what process they will take, but is this something the division can apply for as well?
No, this is something for the taxpayer to decide completely. Now, during the post-audit conference, if there's some discussion with audit saying this might be a very good thing for this particular taxpayer, would make sense, they can certainly make that recommendation to the taxpayer. However, ultimately, the decision is with the taxpayer, whether they want to proceed with the mediation option or not.
And last question here, as far as the selection and disposition of cases, once this mediation program gets going, is the division planning to release regular public updates about that?
Well, when you say regular public updates, I'm not so sure, and I want to make my very clearly, as with any taxpayer matter, there's confidentiality to the mediation and confidentiality of all taxpayer information. So we can't get too deep in the weeds on providing information. Statistical information, however, we can provide, and we'll need to provide that, especially toward the end of the program, when we're trying to make a determination of whether the program should be made permanent or not. So things in the nature of how many applications for mediation were submitted, how many were accepted, how many mediations were successful, resulting in closing agreements, how many were not. Those sort of things, I think we can provide, again, statistical information. But we have to be very, very careful not to go and violate any of the requirements of the Uniform Mediation Act or of taxpayer confidentiality and the statutes relating to that.
Of course. And before I turn it over to Dave, I'm just going to go over some other background on the mediation program and how it's going to be administered. So this will happen once again at the end of the audit process. It's going to be pretty quick as well. Once a taxpayer submits the form NJ-MED, the division is going to answer that form within 30 days.
That is what we have every intention of doing. We'll make every effort to meet that 30-day requirement, because the whole idea of this is to do this relatively quickly. And so 30 days we think is a sufficient amount of time to get back to them. And if for some reason the mediation request is rejected, we will have the reasons for the rejection laid out. And again, we don't know if we'll be just overwhelmed with requests for mediation. And in those circumstances, we can only do what we can do efficiently and effectively. And so the reason for rejecting the mediation conceivably could be we just received too many requests. Hopefully that's not going to happen, but it's a possibility.
And one of the benefits, as well as part of this program, is that both taxpayers and the Division of Taxation will enter into a consent as well, which will give the parties enough time to work through the issues. So if it is just a timeliness thing, it seems like, as long as the taxpayer and the Division of Taxation are willing to work together, both parties will be afforded that time. So that's part of the process as well. You will agree to a statute of limitations extension, and that will give you enough time to work through the issues in mediation. One final element of what will happen as far as mediation, in addition to the form NJ-MED and the statute of limitations extension, you will also sign a contract for mediation with the mediation administrator. We'll go into some more detail with that later on in the program. With that, I'll turn it over to Dave for some additional background.
All right, thanks, Matt. All right, so a couple questions. My personal experience with mediation in other states has been a little mixed. Is New Jersey modeling its program on any particular state or other program in another jurisdiction?
Well, I can tell you we considered several other state programs, and some had good points, which we're trying to include as part of our program. But there were, as you just referenced, there were some troubling factors also associated with some of these programs, and we wanted to learn from these problems to avoid them in implementing our own program. I'll just give you some examples. For example, Massachusetts had a program about 10 years ago. It's still on the books there, but it's no longer available. The person administering the program retired and wasn't replaced. But there were a number of problems associated with the program, and the main one was that the process and procedure was very, very structured and involved, and the process was just too formal, so formal that many people simply didn't want to participate in. Now, we also considered the activities of the mediation process with the New York State Department of Revenue and Taxation. This is known as the Bureau of Mediation and Conciliation. And while they have had a great deal of success in resolving many cases, and I'm told by them that most of the tax controversies go to their bureau and have been, a lot of them have been resolved. I've been told by certain practitioners, perhaps you're going to be one of them, I'm curious, who appeared before the bureau. And they said some of the the New York mediators were not actually acting as mediators, and individuals that facilitate the discussion among the parties in an effort to bring them together to resolve the controversy, but more as arbiters or pseudo-judges who thought that their role was to decide the case in favor of one party or the other. And while, again, we respect what the Bureau has done and their successes, that's a problem, and we don't want to make that same mistake. We're not going to be judges. We are going to be mediators, neutral, and provide facilitation for settlement. That's what the duties will be from this office. Okay. And just one other thing, because just to give the whole perspective, we also considered the statutory method recently enacted by the state of Pennsylvania. But again, we think the procedure in Pennsylvania, at least the way it's coming about now, seems too formal. And under the law, the parties must first agree to selecting a mutually acceptable mediator, which itself is a very long, tedious process. And these mediators would have to be paid by the mediating parties. Our mediation in New Jersey, at least, for purposes of the pilot program, will be offered free of charge.
That's a nice feature, and there's nothing worse than participating in mediation, it being unsuccessful or unfulfilling, and then having to pay for it on top of that.
And the attorneys too.
And the attorneys. Well, that's less bad, but no. I don't have specific experience in New York, but in other states, along the lines of what you said, sometimes the mediator has kind of too much influence or thinks they should have too much influence, or they don't have enough influence and nothing gets done. So finding that sweet spot, I think, really is the key, and it sounds like that's the goal of New Jersey's program.
And I think the main thing with this is we will, do the pros and cons of entering into a settlement. We'll give the benefits to it, and we'll give the detriments to both sides. And just so it's clear that they're aware of those benefits and detriments, so they can make an intelligent decision on whether to pursue the settlement or not.
It sounds like there's going to be a bit of flexibility. Does that extend to how the specific mediations can be conducted, whether it's in person or by Zoom or Teams, by video conference? I mean, how do you anticipate it looking like in practice?
I personally, and all those who have a lot of experience with mediation, tend to think the personal touch is the best, to have the parties there face to face so you can observe all the nuances and the various telltale signs that are exchanged when you're there in person. So that's our preference. However, if there's situations where the individual or individuals involved have disabilities or some sort of other issues, then certainly we can do it remotely. But the preference, and the overwhelming preference, is going to be face-to-face.
Okay, and then it'll be up to the individual mediator whether to keep the parties in the same room, separate them, conference with them, presumably.
Yes, and again, so the possibility, as you point out, keep them all in the same room, going back and forth. Sometimes there may be some level of friction, so caucusing, going back and forth between the parties, the mediator, that is, going back and forth between the parties, may be the most effective way of trying to reach an agreement. So we'll have to take the facts and circumstances, the situation into account and try to come up with the best method.
And as far as the personnel who are going to participate in the program and in specific mediations, there's going to be an administrator oversee the operation. And right now there's 6 mediators that have been identified. Will there be more, or kind of wait and see what the demand is?
Well, that's precisely correct. We have to see what the demand is. We have been authorized to go as high as, at least for the time being, 10 mediators. But again, if there's an overwhelming response and demand, we'll go from the 6 to the 10. But what's most important of all is that the mediators have to be able to do the job properly, which means they have to be properly trained, and that takes a little time. So we want to make sure, again, that they're prepared to do the mediation, and we're going to make absolutely certain of that.
And will the mediation administrator participate substantively in any mediations? Will they be in communication with specific mediators about the merits of cases or strategy, or will they have a role in kind of the audit function, or whoever is going to be the party representing the Division of Taxation in the mediation?
Well, as far as the party, the auditor and the audit supervisor, certainly, they're going to be chosen by the fact that they conducted the audit or supervised the conduct of the audit. But as far as the administrator is going to have a number of functions, including being a mediator and offering advice and counsel to the other mediators, and making sure the program is run efficiently and effectively. The administration of the office will be necessary. There'll be a group of employees assigned to deal with just mediation, and will be under the supervision of the administrator. And again, number of functions that they have to do in selecting which applicants are accepted, and just getting through the process and dealing with those involved in the mediation. So that person will wear many hats.
Got it. And as far as the mediators themselves, they're all going to be drawn from within the Division of Taxation current employees. How you can ensure the division personnel, mediators can remain impartial, will be described their training, that sort of thing.
And as far as the training goes, there's a 5-day course that's offered by the New Jersey State Bar Association that trains individuals, and it's usually lawyers to serve as mediators. But you don't have to be a lawyer to take the course. And under the course, lawyers who receive the training can eventually be certified to serve as mediators in the New Jersey court system. And those individuals are compensated for serving as mediators. The taxation personnel who receive the training, they're only going to be used in this pilot mediation program, or the eventual program if it becomes permanent, and they will receive compensation salary from the New Jersey Division of Taxation. And the fact that the mediators are employed by the Division of Taxation will be fully disclosed and made crystal clear to all those participating in the program. The disclosure will be put in the mediation agreement entered into by the parties, and will be acknowledged by the parties. The mediation training offered by the State Bar Association, just for background, it doesn't just involve tax matters. The training involves a number of subject areas. And the course involves a lot of role playing, where the students play mediators and also actual parties to the mediation, or counsel, representatives of the parties. And I've taken the training myself, and I got to tell you, I think it was excellent. The course is offered in New Brunswick twice a year, in the spring and in the fall. And the course has been given for several years now by noted attorney and mediator, Robert Margolis. Again, he's one of the leading mediators in the state and our region. He leads a team of experienced and distinguished attorneys who have been conducting mediation for many years.
Okay. So division will be represented, by the auditor, supervisor, taxpayer will participate, and then the taxpayer can, if they choose, have an outside representative as well. And that could be a lawyer, CPA, or really anybody that they feel comfortable with representing them at the mediation. Is that correct?
Yes, as long as they submit a power of attorney. And so we have to dot those I's and cross those T's to make sure we're doing it correctly.
Now, if a closing agreement is reached, mediation is brokered, who will review the closing agreement on behalf of the division? Will that be reviewed by an attorney or anyone outside, the audit team, the audit staff, and audit supervisor?
Well, there will be one attorney in the mediation program, and that attorney will be reviewing the closing agreement and making sure, again, all the I's are dotted and the T's are crossed. And because the closing agreement needs that review, because it will be final and it will dispose of the matter. And so it needs review, but it'll be internal, the review. We won't have to go to a DAG or outside of the mediation people to get that reviewed.
As far as the mediation itself, again, going to be flexible, or is there going to be like specific timelines or checklists or kind of a process that the division plans to adopt for this?
Well, there's always a checklist in government that goes almost without saying. But that doesn't mean there's not some flexibility associated with that checklist. And we will go through the process, but there will be flexibility. There's no point in doing a mediation program unless there's some degree of flexibility. So that's going to be ingrained in the mediators. It's also going to be ingrained in the people participating in the mediation program, including the auditor and the audit supervisor. So everybody has to keep an open mind and have some degree of flexibility. That doesn't mean they give away the position, by no means, and I don't want to imply that in any way. But they do have to keep an open mind and have flexibility to participate meaningfully in the process.
So, the end result may not be different, but it's going to be achieved much faster. Is that fair to say? Or do you expect there to be differences in the outcomes?
No, I think generally it's going to be a relatively quick process. Now, that's not all the time. The issues involved may be very complex in some cases. In some instances, be able to resolve the issue after one meeting, or determine that there will not be a successful outcome, meaning a closing agreement based on one meeting. But, and it could take several meetings, and people will be willing to take the time where we think there's a possibility of success to devote time to those extra meetings. And in a few instances, we may get to the point where the statute of limitations is about to run within the 180 days. And if the parties both think it's worthwhile and they want to extend the consent, that will be permissible. But that's going to be fairly rare.
Okay. And just to wrap things up, if you were to get in a time machine and, going into the future to when the mediation program is just set to end. And if you review the statistics and the records and disposition of cases, you know, how will you evaluate the program? And you know, what would you need to see in order to deem it a success?
Well, the ultimate people who are going to be reviewing this, of course, will be people in taxation management, the director, the treasurer's office and the treasurer, and also whoever is in the governor's office 2 years hence. So those are the primary people. But from me, my perspective is that the program will be successful if there is a significant participation in the program by taxpayers and the representatives, and that in a significant number, I won't quantify it, but a significant number of closing agreements were arrived at and entered into. That would be wonderful. And then the question becomes at that point, at the end of the pilot program, how do we proceed from there? And do we just rely on the current program, doing it through closing agreements? Or like in Pennsylvania, they just recently passed a whole statutory scheme to deal with their mediation program. And that's a matter really for people with a higher pay grade than me to decide. It'll be the legislature at the time, the governor's office, the treasurer. But I'm optimistic. I think this program's going to work, and I think it's going to have a lot of interest, and I think it will be productive and beneficial for both the state, Division of Taxation, and for taxpayers.
Those are some nice closing thoughts. So just a couple more points. If it's successful, presumably it could be expanded to other taxes. When would that determination be made? Would it be after the pilot program? If it goes well, might it be instituted during the pilot itself?
I don't believe it has any possibility of being instituted during the pilot, but certainly after the pilot is completed and based on our evaluation, there will be serious consideration given to expanding it to other taxes, especially the GIT.
Okay. Will taxation be soliciting feedback and advice from taxpayers and practitioners as this program moves forward?
Absolutely. We'll want to get their feedback. As a matter of fact, as we've been developing the program, we've been talking somewhat informally to certain practitioners and getting their input. So the program is being developed, the technical bulletin, the agreements that we are going to, that's going to be part of this, the applications and the mediation agreements and the like. We've had input from, valuable input from tax professionals, and we appreciate it. And that input will continue through the pilot process.
Okay, great. Well, that's everything we had. Is there anything else that you wanted to comment on or mention?
That's about it. I think we covered everything from soup to nuts.
Yep. We appreciate it, and certainly if anyone that's watching this has any questions, please feel free to reach out to either me or to Matt about this or any other New Jersey or state tax issue generally. Thank you.